The first part of my second video referred to the charity law case, which reveals the Attorney General's fundamental conflict of interest that goes to the heart of the first duty of government, the peace and security of its people. This case concerns the Project on Demilitarisation, or Prodem for short. I alone edited 4 out of 6 Prodem briefings in the period 1992 to 95, predicting war out of the Cold War, as my first video explained. The question was whether these briefings were genuinely educational. Decide for yourselves, after viewing this second part of video number 2, whether this is indeed a graphic story of skulduggery in high places that has decisively affected your future peace and security. If it is, as I seek to demonstrate, the biggest cover-up in the modern history of English civil law that continues to this day, then the third and final part of the video will suggest what you can do to help rectify the situation and what are likely to be the costs to all you hold dear if you don't. I brought the Prodem legal case in 1995 to establish the principle that what I called an Irenical perspective is the basis for genuine education. Irenical is from a Greek word meaning aiming at peace. I claimed that isn't pacifism, but isn't indifference between peace and war. The courts later agreed that an Irenical perspective isn't pacifism, nor is it itself a political purpose, because it generally prefers peace to war. The High Court judge, in his judgment of the 9th of October 1998, at paragraph 26, described with approval an Irenical perspective as an educational purpose which starts from the assumption that peace is preferable to war and therefore puts the emphasis on peaceful rather than military techniques for resolving international disputes. This is true even if one purpose of such education is to create a public climate for peace. The Attorney General opposed the principle then, and every Attorney General since has continued to oppose it without passing parliamentary legislation to override the judge's view. They gave no reason. My co-trustee and I, as appellants, won the principle emphatically in the Court of Appeal on the 28th of June 2000, the anniversary of the assassination that sparked the Great War in 1914 and the Treaty of Versailles in 1919 that created a climate for what became the Second World War. The court also dismissed the charity regulator's claim that Prodem was arguably promoting pacifism. But we lost the case because the judges concluded we were trying to achieve a state of peace through demilitarization. They noted, though, that I denied this and had provided a detailed skeleton argument to explain why, which they did not address because they thought it unrealistic. If anyone thinks the judges were right, they have to explain, first, why the judges provided the appellants with the precise wording of the objects of the International Peace Project 2000, or IPP, to continue the work I had started in Prodem and establish the trial peace games in 2004. Secondly, what prompted the judges to tell a lie? Yes, to tell a lie in arriving at their decision on Prodem's charitable status, which undermined their claim that the evidence concerning Prodem's purpose was firmly against my view and intention. I was in court on the 10th of March 2000 and saw that the judges were placed under great political pressure by the Solicitor General himself, entirely unnecessarily, I should add, because it was clear to me from the tense atmosphere, almost from the moment the judges walked into the courtroom, that they would be unlikely to allow the appeal. This showed me how this political role undermined the Attorney General's claim to be a law officer and public protector of charity. The evidence of the appeal judges having falsified a material fact was sent in writing to the lead judge, who regretted and did not deny it, and later copied to the Attorney General's office, so they knew, I knew, what had happened. So then, the Attorney General, as law officer and public protector of charity, knew that the Strategic Defence Review 2025 abandoned the Irenical goals of NATO's London Declaration of July 1990. In that document, which declared that the Soviet Union and its Warsaw Pact were no longer enemies, NATO's stated goal was, quote, to create enduring peace on this continent, unquote, meaning Europe. This isn't mentioned in the SDR 2025 because, as the Russian invasion of Ukraine on the 24th of February 2022 demonstrates, NATO's purpose had failed on its own criterion. More effective than lying, the SDR reviewers omitted a material fact and a relevant legal case in which my predictions of war were written into the appeal judgment. I tried to warn you and your forebears of the coming great power war, which the Strategic Defence Review 2025 has belatedly recognized. But it's preparing you psychologically for this likely war on an untruthful and deceitful basis, as I explained in my first video. Skulduggery and cover-up, I alleged. No one else exposed it or could have done so, because only I was present by the grace of God on every occasion when it mattered. It is now simply a question of fact and of trust assessed from an Irenical perspective. The third and final part of this video outlines my standing to expose the consequences of the Attorney General's conflicts of interest and why you cannot trust him as law officer and public protector of charity where securing a state of peace is concerned. Instead, there is an educational option that involves no political action whatsoever.